Good afternoon. Please be seated. Two cases on the docket. The first will be 14-24-00509, Bell v. State. Y'all are ready to get it? I'll take it.
Dulcie Schindler from the Harris County Public Defender's Office for Samuel Bell.
This is Stryker from the Harris County District Attorney's Office.
I see. Would you like to reserve time for rebuttal?
5
minutes. Whenever you're ready.
May it please the court. I'm Dulcie Schindler, as I mentioned, from the Harris County Public Defender's Office, here for the appellant, Samuel Bell. Mr. Bell is here seeking reversal of his DWI conviction based on the fact that the trial court wholly failed to instruct the jury about the applicable law in the case. From the very beginning, Mr. Bell anticipated presenting a defense of necessity, which is authorized under Section 9.22 of the Texas Penal Code. And even in the voir dire proceedings, not only did Mr. Bell, but the trial court himself question the jury about the necessity defense and their ability to consider it. So that was obvious going into it, that was going to be his defense. It was found himself in a very difficult situation. He had consumed alcohol. He admitted that he had consumed alcohol, but he was frightened for his life, and so he made a split-second decision to leave despite the fact he had consumed alcohol. And he ends up, arrested and pulled over. Well, he wasn't pulled over, he was asleep behind the wheel. And the police officer who arrested him did not question him about, obviously anything about where he'd been or how much he'd consumed or anything like that. But in trial, he clearly admitted that he had been drinking.
Where in the record does he admit that?
That is on, there's several places, but to me, the most obvious is in volume 3, page 106, where he says there was alcohol in the drink, and his attorney asked him, well, did you feel intoxicated? He says not immediately, but he knew he needed to leave. He said that he consumed 1.5 strong drinks while he was there that he had not requested, but the gentleman whose house he was at offered them to him, without him even requesting it. He wasn't out on the town. He wasn't out, he had been living in his car for several weeks, and he just wanted a hot meal and a bed to sleep in, and that's why he was there.
Let me go back to the record. At some point, I can't remember if it was on cross-examination or on direct examination, where the question was flatly asked, was he intoxicated as he left the client's home? And I believe his answer was no.
They asked him, did you feel intoxicated? And his answer was no. But feeling intoxicated is not an element of DUI. Plenty of people don't feel intoxicated at a .08, they're still guilty.
Except he was a .13.
Yeah, well, I know that, but I mean, plenty of people do agree to, perform the field sobriety test because they think they don't feel intoxicated. You don't have to feel intoxicated to be guilty of a DUI. That's not an element.
Does that contrast with what you started with, saying that he said what he did admit to is feeling lightheaded while he was in the trailer? That's not intoxicated either, correct?
Well, but feeling intoxicated isn't an element of DWI. He could say, I never felt intoxicated, and he still can admit to committing DWI. So it's not, you don't have to feel intoxicated to be guilty of DUI.
So him stating that he didn't feel intoxicated, but knowing he'd had maybe some alcohol that the client had provided, that to use an admission of guilt to the elements of the offense of DWI that would entitle him to necessity defense.
Yeah, and at one point, he says, when they are questioning him about whether or not he'd turned the engine off in his car, and he says, well, I think I turned the engine off because I know that if the engine's running, they can charge me with DWI. Like, hello, I just admitted that, had I, turned off the engine, maybe that wouldn't have been the case. So he admits to the DWI. I think what he's trying to say, my impression of the record, was that he was so anxious and he had so much adrenaline pumping through his system because he was so scared. Adrenaline can override the feelings of any kind of intoxication. So I think what he was saying is, well, I was just scared. That's how I was feeling, really, really scared. And so that's why I immediately felt like I had to leave. And so, you know, he clearly, and like I said, the court knew from the very beginning that that was going to be his defense. And when the court denies the instruction, they say, he literally says, he didn't admit to feeling intoxicated. And that isn't an element. He doesn't have to feel intoxicated. And in addition, the second part of his defense had to do with the voluntariness, of his consent to the blood draw. And I know that there's a question about whether or not there was a fact issue in that. I'm sorry. Feeling for a minute. But so there is definitely a fact question, and I'm not sure that I articulated it very well in the brief.
Do you need some water?
You want to take a minute?
No, I'm going to finish. But I refer you to Chambers v. State, which is 663 Southwest 3rd 1. And that case is very similar to this case, and that is a 2022 Court of Criminal Appeals opinion where they reversed the Texarkana court for not including the 3823 instruction. And in that case, the police officer testifies in the courtroom that he pulled over Mr. Chambers because Mr. Chambers did not have a license plate. Well, in the scene video, you can see a tag. You can see that he's got a temporary tag in the back of his truck. So the state argued that, well, the facts are clear, you know, you can see it in the video. And the Texarkana court agreed with that. Said, yeah, you know, that's not a fact question, you can see it in the video. But the Court of Criminal Appeals said, no, that's not all right. Even if, because there was a fact, because the police officer, even if he was wrong or lying, testified that, you know, he pulled him over for that reason, the jury had the right to make basically a credibility decision about, you know, whether or not that stop was legal.
So that's a disputed fact,
Mhm.
right? The officer says that the reason he stopped him was for not having a license plate, and in fact, the body camera or the dash cam shows otherwise. So that's a fact that's in dispute.
Mhm.
What fact is in dispute here that would entitle Mr. Bell to the voluntariness instruction in the jury charge?
Well, in the courtroom at trial, Officer Tournier testifies that Mr. Bell was under arrest right after he conducted the field sobriety test and he felt that Mr. Bell had failed them. Then, if you watch the video, there's a point when he's explaining the DIC-24 where he says to Mr. Bell, look, if you consent to breath test right now, this was after he'd done the field sobriety test, obviously. He says, if you consent to a breath test right now and you blow under a .08, I'll let you go.
But the state concedes to that.
I know, but when you're looking at the coercion element, right, that's what the jury was supposed to consider. Was his consent voluntary or was it coerced, right? So if the jury believes that he was under the trial testimony that he was under arrest right after the field sobriety test, they might consider that very coercive, that he was telling him he'd let him go when he really wouldn't.
Did your client provide a breath test in this case?
No, he did not.
Okay, so even though the officer explained to him incorrectly
Mm-hmm.
that if he blew below a .08 he would be released, incorrectly, because that's not, I don't believe, is what would have happened.
Right.
He chose to provide a different test than the one the officer mentioned. He provided a blood consent, did he not?
Well, there's some debate about whether or not he actually consented,
Sure.
but for the sake of argument, let's assume that he did consent. Whether or not that consent was voluntary would be the question for the jury. And that would have been what would be presented to them as a 3823 instruction. And if you look at the denial of the motion to suppress, when the trial court denies the motion to suppress, this is what he says. He says, on this particular issue here, at no time did I hear him state, I'm not going to do this, get a warrant. Through the whole thing, I have not yet heard him say, I'm not going to do this, get a warrant. So I'm denying your motion. So he literally denied the motion to suppress just based on the fact that he thought he had consented and did not evaluate whether or not he had been coerced at all. So not only has nobody ever evaluated whether or not his decision to leave that house was reasonable and apply the necessity defense, no one has ever considered that. No one has ever evaluated that. Also, no one has ever evaluated, no one has evaluated whether or not his plea was, his decision to, consent to the blood draw was voluntary. None of this, his trial was not a trial on guilt innocence. His trial was basically a prolonged guilty plea. And I can imagine that during jury deliberations, that jury was like, why did he not plead guilty? They had no choice but to convict him. None at all. So that's not a trial guilt innocence, that is, you know, unfair. I mean, none of his defenses were ever considered. So he deserves to have that opportunity, and I hope that this court will give it.
Thank
Thank you, ma'am.
Mr. Mayor.
Good afternoon, and may it please the court. Again, my name is Melissa Stryker, and I'm here on behalf of the Harris County District Attorney's Office, representing the state of Texas in this case. I want to begin my argument today with a rebuttal to counsel's argument that an admission to drinking constitutes a sufficient admission to intoxication to warrant a necessity instruction. That's simply not the case here. The Court of Criminal Appeals has affirmed repeatedly, and most poignantly probably would be Maciel, which is cited in my brief here and is distinguishable on its facts. But the underlying legal aspects of Maciel are that the Court of Criminal Appeals has affirmed that the necessity instruction is a confession and avoidance doctrine-based notion wherein the defendant must admit the culpable conduct in order to receive the necessity instruction, which would justify that culpable conduct. That simply did not happen in this case. The defendant neither admitted at the scene to Officer Deputy Tournier at any point, nor during his testimony at trial, that he was intoxicated.
Counsel, I understand what you're saying, but it's not like they're requiring the defendant to say, I lost the normal use of my mental and physical faculties during trial. I don't think that's quite the standard. But at the same time, how close do you have to get? Is she close enough, or why do you think she's not close enough, specifically with what she stated in her reply brief about admitting that he felt lightheaded, or whatever the phrase was in the reply brief, and why that is not close enough to intoxication?
So if you look at the facts of Maciel, that will be instructive by contrast here. You don't have to state with specificity. He doesn't need to get up on the stand or even at the scene and admit, I'm intoxicated because I've lost the normal use of my physical or mental faculties. But he does need to say something to the effect that would be tantamount to that legal definition of intoxication. So saying I've had a drink or two, that's perfectly legal if you haven't lost the normal use of your physical or mental faculties. So him admitting that he had a drink or two and then started to feel anxious or threatened by his client's behavior is not an admission to intoxication. So none of the evidence that counsel cited either here or in her reply brief gets to that. There's simply no either express admission to intoxication or an implied admission based on any of the factors that the defendant did testify to that would amount to an admission to intoxication. An interesting notion is that the state's evidence of intoxication, because of course we presented abundant evidence that he was in fact intoxicated, that cannot supplant the defendant's own admission, or that would completely undercut the viability of a confession and avoidance doctrine entirely. So to any extent that counsel might suggest the state's own evidence would supplant the defendant's confession, that also is not applicable by virtue of Maciel and the jurisprudence that follows that. And we know that because in Maciel, the Court of Criminal Appeals repeatedly references the defense's testimony or the defendant's specific testimony where she discusses operation in that DWI. Was a different element at dispute in that case. But by repeatedly coming back to the defendant's own discussions about, she basically said that she was trying to operate the car, but she didn't believe she had legally operated it or driven it because she was unable to actually make the car move because the parking brake was engaged. So in that instance, the defendant did not specify the legal definition of operating as case law has interpreted it, because of course it's not defined by the penal code, but got close enough to the element of operation where a jury could reasonably infer that she had testified to it. The Court of Criminal Appeals remarked about the defendant's testimony in Maciel at least 4 times when going through their analysis and in reaching their holding, and otherwise referenced the defense's testimony several other times. So again, as this court's looking through this, it's important that this court focuses on what did the defendant testify to in this case, And the simple fact is, he did not testify ever that he was intoxicated, and in fact, flatly denied that he was intoxicated on cross-examination. And because he did not admit it, he is not entitled to the defensive instruction of necessity. Going back to counsel's points about the voluntariness instruction, whether he was entitled to it or in fact raised any sort of issue at all, the record again is clear that there was not a fact issue that related to a material aspect of this case. So whether he was tired or had some other justification for being on the road at that point has no bearing on whether he voluntarily consented to a blood draw. So because all of the fact issues that there really weren't any fact issues that related to a material part, it came down to a legal question as to whether the defendant's consent to a blood draw was voluntary or involuntary. That was properly a question that was solely for the trial court in this instance, not for the jury.
Are you familiar with the case that was cited by Mr. Bell, Chambers v. State?
I'd have to review that.
That's fine. I guess let me use her rendition of the case, that the police officer in that case stated that the reason for the stop was a no license plate, and in fact the dash cam or the video showed that there in fact was a paper plate on the vehicle. That certainly seems to be a disputed issue. Is there anything in the record that comes close to being a disputed fact regarding the voluntariness of his consent after, admittedly, the constable makes that statement several times, you know, if you blow below .08, you will be released?
So based on counsel's representation of the facts in Chambers, it sounds like the issue at question would be the legality of the traffic stop in that instance. And so if the facts from the defendant say, you know, I did have, you know, license plate, the video shows otherwise, that would be a question of historical fact that's disputed by the evidence that's presented. That is material to the statutory violation or constitutional violation that the defendant is claiming occurred. So in that instance, the requirements for a 3823 instruction would be met. Here, where there is no dispute about what was said or what the defendant's response was, you don't have a disputed fact in the same way. And I would argue that the record supports that there was nothing that occurred either during their conversation while the officer's reading the DIC-24 to the defendant as he sits in the backseat of the patrol car, or subsequent to that, attendant to the blood draw itself, that created any sort of dispute. State's Exhibit 4 is the video of the blood draw, and the hubbub during that blood draw centered solely around the defendant's request to use the restroom and have a glass of water at that time. There was no expression by the defendant that he had not consented, you know, confusion as to why they were there, what was about to happen. There was no expression by the defendant that he wished to revoke his consent to provide a blood specimen. It was solely about whether he could be given water and access to the restroom before the blood draw was actually occurred. So again, the record does not show that any sort of subsequent fact issue arose even after the defendant initially provided his consent for a blood draw. So taking the record as a whole in its entirety, there simply is no disputed fact here, which would warrant a 3823 instruction. There aren't any other. Yes, sir.
So, a little bit deeper, not really related. The blood draw, did it test only for alcohol or did it test for other substances? And if it did, was there anything else found?
I don't believe there was any other result other than the 0.13 for ethanol. It may have tested for some other substances that might be part of a standard blood analysis, but relevant to this case, it was only the ethanol result that was admissible and relevant. If there aren't any other questions, then I will rest on my brief for the remainder of the arguments and pray that this court will affirm the judgment and decisions of the trial court. Thank you.
Thank you, Counsel.
May it please the court. Again, the record speaks for itself, obviously, but I would again just reiterate the fact that he definitely admitted that he would be guilty of DWI if it was in his running. Like, he admitted that if saying am committing this offense isn't admitting to the offense, I'm not sure how you admit to an offense. But he clearly does that, and you'll see that when you review the record. Also, with regard to the voluntariness of, no, this wasn't a legality of the stop case, but it was a case about the voluntariness of his consent to the blood draw, and the very basis of his argument that it wasn't voluntary was that he was coerced. So the jury, if they had received the proper instruction that they were entitled to have, would have been able to evaluate the level of coercion that was imposed upon him before he consented, if he did indeed consent. And they were not given that opportunity. Fact question that they would have considered, when they were evaluating the level of coercion would be, was he under arrest after the field sobriety test, like he testified to in court, or not? If he wasn't under arrest, then that's not that coercive, because the guy's he's saying, look, you're not, you can go if you don't blow a .08. If he is under arrest, that's pretty coercive, because he's lying to you. So the jury didn't have a chance to evaluate that level of coercion and determine whether or not that ultimate consent was voluntary. And if you watch, I'm not arguing that he didn't consent, but if you watch the blood draw video, just the scene from the JPC where they're taking his blood, if somebody watched that with no knowledge of the case and was asked to describe what's happening here, they would say a man is being forced to turn over a blood sample. That's what's happening in that scene. I mean, if you didn't know anything about it and you just watched that and you were asked to describe it, that's what you would say. Oh, this is just a man who's having to, forcibly turn over his blood sample. The jury was never given the opportunity to determine, was his consent legitimate? And they should have. That's the point of the 3823 instruction. And I think that you'll notice that the Court of Criminal Appeals is pretty strict. They're pretty strict about this. They like the jury to get this instruction when they need it. I mean, this case, Chambers, is a 2022 case, and it was almost nearly unanimous. I think Keller dissented, but that's not surprising. Where they say, you give this instruction. If there's any kind of fact question, if there's anything that the jury could evaluate to determine whether or not, the actions were legal, give them the instruction. Err on the side of giving these instructions so that people can have fair trials. That's why that's supposed to be the whole point. And Mr. Bell never had a trial. He had a 2-day-long guilty plea. That's what he had. Because nobody ever considered his defenses. No one was ever given the chance to consider his defenses. And for that reason, I really hope and pray that you give Mr. Bell the opportunity to have a fair trial and a jury to consider his defenses that he is entitled to present. And with that, unless there's any questions.
Yes. All right. Thank you.
Thank you.
Thank you for your arguments. 1424-00509 is submitted, and we'll take up the next case whenever y'all do a set change. All right, next is 1424-00506. Everybody's ready?
We are,
Okay.
Kyle Zoker here on behalf of the appellants. Matt Allen on behalf of the appellees.
All right. How about rebuttal time? You want some rebuttal?
Yes, Your Honor, 5 minutes.
Okay. All right, whenever you're ready.
May it please the court. This is an appeal from a default judgment with two added wrinkles. First, there's a procedural issue. The trial court orally ruled that VA and GVM, the two LLC defendants, were entitled to a new trial, but did not issue a written order until the day after the trial court's plenary power expired. Second, there is a Rule of Civil Procedure 320 problem with the trial court's intended rulings. First, the trial court inappropriately severed the case via a motion for new trial, even though Rule 320 does not permit claims to be severed unless they are clearly severable. I'll show that these claims are the exact opposite of that. And an extension of that, the trial court impermissibly ordered a new trial on unliquidated damages alone when liability is contested. So today I'll explain why the appropriate remedy from this court is to grant all four of the appellants a new trial as to both liability and damages. So the first determination this court has to make is, was the trial court's order signed on July 25th, 2024 valid? Now, to some extent, I wish it was valid, because this order grants two of my clients a new trial, but it doesn't matter what I want. The law here is a really bright line, clear rule. Under 329 BC, a written order explicitly granting a new trial is required for a new trial to be granted. Partner Freight argues, well, if we look at the record, we see that the court rendered judgment orally at the hearing, and this was just a ministerial act. That argument works in a lot of contexts. It does not work in the context of motions for new trial. The Texas Supreme Court has already addressed that argument and overruled it in the case of Enri Levito cited in our briefing. So there's really two tracks here, and it's one of the reasons that I wanted to have an oral argument is because it's sort of a conditional case. Either the trial court's order is valid or it's not. I'm going to take up the first scenario first. Partner Freight's saying, look, this order is valid. Okay, if that's the case, then my two LLC clients, VA and GVM, they have a new trial. And Partner Freight cannot challenge that on appeal. They cannot challenge that because, one, Texas law does not allow an appeal of a granted motion for new trial. That's the Texas Supreme Court case of Freehoff. And two, they did not file a notice of appeal or a cross appeal. So under Rule 25, they can't challenge that. And if that's the case, then we're left with one problem, which is the two individual clients of mine, Thack and Wynn, they now have been denied a motion for new trial on liability, but given a motion for new trial / hearing on damages alone. And in that case, I've asked in the briefing, and I'm asking now for the court, if your honors say yes, this July 25th order was valid, then I respectfully ask that my notice of appeal be treated as a mandamus pursuant to the legal authority permitting that. And in that case, I would show that the trial court abused its discretion and that mandamus is appropriate to address this problem of splitting the case impermissibly and ordering a new trial on damages alone. They have to be clearly separable in order to have a partial new trial. The Texas Supreme Court in State Department versus Cotner, cited in our briefing, explained it thus. The claims must be not so interwoven with the remaining actions that they involve the same facts and issues. Here is what we have in this case. A single measure of damages, a single contract, a single alleged breach, the same alleged fraud, the same negligent misrepresentation, and the same unjust enrichment. And Partner Freight alleges that the legal distinction between the four parties, the two LLCs and the two individuals, should be disregarded, and that they should be treated as interchangeable under the alter ego theory. You cannot have more interwoven claims than this. They're literally saying all of these four people are interchangeable, so treat them all the same, and yet now we have a bifurcated or a severed proceeding, and it raises a really troubling question. How can Thack and Wynn already be found liable for claims that their liability is derivative of claims that have not been adjudicated yet.
So why did the trial court do that? Why did it sever the claims? What was the reasoning?
What it appears from the record in the trial court is that the trial court found no service
Correct.
was proper on VA and GVM, and service was proper on FAC and WIN.
And is that not permissible?
That it's that finding may be permissible, but you cannot grant a new trial for VA and GVM and already find liability as to FAC and WIN because all of the claims are interwoven, and Rule 320 does not permit a partial new trial. If it's a new trial for one, it's a new trial for all if the claims are interwoven and derivative and they're alleging alter ego. And so an extension of that is the well-established rule that you can't have a separate trial on liquidated damages alone, which is just another instantiation of that rule. And mandamus is not a typical relief in this context, but the Texas Supreme Court has said there can be exceptional circumstances where it's appropriate. That's from Henry Columbia, 2009 case, and the court really emphasized in there not wasting the court, the jury, and the parties' times. And respectfully, that's exactly what's going to happen here if this goes back down, and we're going to have a trial as to appellants VA and GVM, but not as to FAC and WIN. They're going to be deprived of due process. And if our adequate remedy is just to wait for that whole thing to play out and then come back to this court after it's done, respectfully, that's a massive waste of everyone's.
Then why didn't you concede to service so that the claims would not have been separated? That would have prevented that issue.
We did concede to service with regard to FAC and WIN. We did not concede to service for VA and GVM because they were not properly served. And moreover, our primary...
If you had conceded, let's just say for sake of argument, if you had conceded that they were properly served or had accepted the service as it was made, then the claims wouldn't have been split by the trial court.
Perhaps, but then we would have basically given up everything because we would have surrendered our right to a motion for new trial.
I guess that's my point. You want to have your cake and eat it too.
We just want to have our day in court on these claims. And the other part of the argument that I'll get to with Your Honor's permission is if the order is not valid, if this July 25th order is not valid, then we've got the April 10th order granting default judgment. That's the final judgment. It's undisturbed. Two problems with that. One, there was no proper service on the two LLC defendants, appellants VA and GVM. Here really quickly are the facts. The petition requested service via John Varelst, the registered agent. The citation was addressed to John Varelst, the registered agent. The return was not delivered to John Varelst. It was marked as an unsuccessful service, and then it listed George Green, VP. It called itself unsuccessful, and there was never a second return of service for VA or GVM. Here's what the law says. If you have the name wrong, it's improper service. In the pharmacokinetics case that we cited extensively, the return of citation showed it being served on Charlotte Young when it was addressed to Steve Woodman. The court held improper service, no due process. In the Mega v. Anglo case we cited, the return showed it being addressed to A.R. Martinez Jr., not effective when it was addressed to A.R. Tony Martinez. In the Fleming case we also cited, they got one letter wrong. Instead of K-E-D-D-R, they put K-I-D-D-R. The court held not proper service. So this is not a novel issue. It's well established in the case law that an improper naming leads to improper service. And ultimately, what they're relying on is that, well, Green held himself out as VP. Nothing in the record shows that he ever held himself out as VP. They're relying on the process service notation VP next to his name, the same return that says unsuccessful. There's nothing in the record to show he held himself out that way. Also, VA and GVM are not corporations, so there are no vice presidents who can accept service. They're LLCs. Ultimately, what Partner Freight's asking...
And he was a managing member, wasn't he?
Yes, Your Honor, he was a managing member.
That isn't enough?
A managing member can accept service on behalf of an LLC My point here is, one, the record is very muddy as to what the service was. He's only the managing member of one of the entities. It's escaping me which one it is at this very moment. And what we have here is everything in the record shows they were trying to serve John Burrell, not George Green. They didn't do anything to clean it up. No amended petition, no amended citation, no motion for substitute service. They're asking for presumptions, and the Texas Supreme Court in Spanton v. Bella said strict compliance, no presumptions, no assumptions. I reserve my rest for.
Thank you, Counsel.
Good afternoon, Your Honors. May it please the Court. Again, my name is Matt Allen. I'm here on behalf of the appellees. Before I address counsel's arguments here, I'd like to talk a little bit about just a little bit of the background. Specifically, the appellee, Partner Freight, is a small logistics company in southern Missouri County. Very simply put, they were hired to deliver services and materials to a solar farm out in Edna, Texas. Not 1 cent was ever paid to them. This is over a span of about 2.5 months. Specifically, part of these issues dovetail into the service piece. Again, trying to get in touch with these people, extremely difficult. As to, sorry?
No, I just, sorry.
Sorry.
Pollen, that's the pollen.
I hear you. With that being said, specifically as to the background is we're forced to file a lawsuit. With that comes service. Difficulties in serving the other party arose. Specifically GVM and VA, when we served them at their address that's listed with the Secretary of State, there was no registered agent that was available. Someone named George Green accepted service. Now, I disagree with the premise that you cannot have a vice president or president of LLC. You absolutely can. LLCs are extremely flexible. That's well established, and somebody could represent themselves as vice president. I don't know. I wasn't there as the process server, but we do have a sworn affidavit saying he was served. Now, what I will agree with on counsel's point is that the trial court did grant GVM and VA a new trial. We did not object to that. We didn't ask for a motion for consideration. So in my opinion, that issue is moot. However, it was raised in their briefing. We responded to it. And so I'm not sure that issue is really relevant for the court today. I believe there's two issues here. One being plenary power, whether it was exhausted, and two being service on Thatch and Lynn. Specifically as to issue one, the plenary power part. The trial court signed a default judgment on, I believe it was April 2024. The counsel's clients, the appellant, received notice of that judgment in accordance with the rules of civil procedure that put them on notice that they had a default judgment entered against them. They turned around in May, filed motions for new trial. At motion for new trial, we had a hearing on that. The judge clearly and in the record states that here's what my ruling is going to be. That was an oral ruling. It was not signed. I agree that 329BC does state that a default judgment must be signed. However, there's a couple caveats to this, as with all things that we do. There's exceptions. They filed a motion for new trial, and then within 5 days, and back up, at that hearing, trial judge instructed the appellants to prepare an order. That order was never prepared at that time. 5 days later, they then filed a motion for reconsideration, basically in writing, transcribing what the court's ruling was. So again, they're trying to sit on two sides of the fence here as to, well, there was no ruling, but yet their motion for reconsideration 5 days later acknowledges a ruling or an order. And I have not been able to come across a case, I have not seen any precedent that addresses that issue. That's what we're really talking about as to, had plenary power really exhausted or not, and had there been an order signed. There was no order signed.
So you're saying that they're filing the motion for reconsideration despite the fact that the ruling was in the docket sheet, it was a docket entry, that somehow changes the rule that the order must be written?
Not that it changes, Your Honor, that it creates questions. It creates exceptions as to what realistically was the statute intended to do. Was the statute intended to let everybody know that there was a default judgment entered? That's what I believe, is so that we're not convoluting these issues. But there was a docket sheet, there was a record made, and then there was a motion for reconsideration that states there was a ruling. I do agree that the statute states that. This issue just has never, well, it probably has come up, it's just never come up before the Court of Appeals or a Texas Supreme Court case that would show us how do we address these issues. Originally, the statute was put in place to eliminate confusion. I don't believe anybody was confused here, and so I'd ask the court to at least consider that, not asking you to create new case law, but I believe it should be considered as to these specific circumstances. Moving forward, we talked about service of GDM and VA. Again, the court granted them a new trial. No objection, there was nothing on our part as to that. Specifically though, as to Thatch and Wynn, they were served. Not only were they served at their personal residence. Their affidavits that request a new trial because they employ the Craddock method in the Craddock test, and specifically that is, if you don't answer, it's not due to conscious indifference or mistake. Second is that they allege some or bring forth some meritorious defense. And third, does it cause undue delay or cost to the plaintiff? Well, I can tell you this, the first piece, they absolutely knew they were served. It was handed to them at their house. This was not done at an office somewhere. And specifically, their affidavit says it was. If you look at the return of service, that is their home address where they were served. Their affidavit says they were served somewhere else. That's disingenuous just on the face of the document. That is untrue. And again, this goes back to the whole issue. They're trying to avoid paying for something that they received. They've never raised a defense that the materials they received were wrong, they were not as agreed upon. Nothing like that was raised. Their only defense is raised in their briefing. But if you look at their motion for new trial, it doesn't have anything other than, oops, we didn't realize that we're supposed to respond to this. Well, that's not the Craddock standard. That is specifically what it says we don't allow a new trial for. And that's what the trial court was trying to impose. And so when, in response to counsel's argument and the appellant's argument as to whether they were served or not and whether they presented a case that meets the Craddock standard, I disagree. I believe this court should find the same. Moving on forward, as to the bifurcation severance, what was the court supposed to do? They had two defendants that did not answer. They did not go ahead and issue or rule on damages that day. Trial court specifically moved those to the side because we're going to have to hear that later. Now, if the LLCs are found to be not liable, well, we still have personal liability, and that's when those damages would be heard. There was no hearing set. The court didn't try to set a hearing. And so I disagree with the bifurcation severance argument because it simply didn't happen. We just have liability. We don't have damages. There is no judgment except for you didn't answer the lawsuit. From that, Your Honors, that's all I have, unless there's any questions.
Okay. Rebuttal?
May it please the court. So let's talk about the application of Craddock to Thatch and Wynn, since it sounds like VA and GBM is not at issue. They have a new trial. Okay, the Craddock has three tests. First, that it's not intentional or conscious disregard. Second, that you present a meritorious defense by affidavit. And third, that there's no delay or prejudice. With regard to the first, the Texas law is very clear, came out of the Texas Supreme Court as recently as 2021. When you put forth affidavits setting up that it was not conscious indifference, and the other side does not controvert those by evidence or counter affidavits, they are taken as true. That comes from the case of the matter of marriage of Sandoval, Texas Supreme Court case of 2021, cited in our briefing. We cite numerous other cases, but I'll just give you the latest and greatest out of the Texas Supreme Court. And at the trial court level, we presented a list of cases showing what the Texas Supreme Court has found to be sufficient to establish that element. And for your notes, that's on clerk's record at page 183. And you'll see here the first 4 cases in this bullet point list. They're things like defendant's agent testified he did not remember being served. The citation was left in a stack of papers on a desk and forgotten. Could not verify that the documents were ever forwarded. So these are like honest, simple mistakes. That's exactly what you're going to find in the affidavits from our clients in this case. And they did not present any counter affidavits. They didn't request an evidentiary hearing. The argument of counsel at the hearing was, well, they were served. Well, okay, they were served. We don't even do the Craddock test unless they were served. So the fact that they were served is not a counter argument to Craddock. We have set forth the not intentional / conscious disregard. They haven't contested it. Texas law is clear. The court takes it as true. Second, on the meritorious defense, I heard from counsel like, well, they have no defense. They just say, well, sorry, we forgot to answer. Not true. We specifically said in the affidavits, these are not liquidated damages. There is no affidavit in the petition. It's not a suit on sworn account. There was no affidavit in the motion for new trial. It's just some statement of a dollar amounts attached to a petition, not supported by affidavit. We said, we're challenging these amounts. We don't know how you calculate these amounts. These amounts are not known to us. So that is a meritorious defense. And the case of Jocko v. Rivera, which came out of this court in 2009, this court held, if you challenge the amount of damages, that's a meritorious defense. You don't have to challenge the whole thing, everything. You don't have to challenge the core liability. If you want a reduction of damages for the purpose of Craddock, that's a meritorious defense. Also, in the trial court, and it's in the reporter's record, trial counsel raised the additional meritorious defense that GVM, FAC, and Nguyen are not parties to the contract that's at issue. It's only VA. It's a contract between Partner Freight and VA. So that's yet another meritorious defense. And that can be found, I'll get a cite for that. The third point, no delay in prejudice. The Texas Supreme Court case of Dolgengorp versus Lerma, 2009, clearly said, look, if you aver it, and you're the defendant and you aver, this will not cause delay, this will not cause prejudice, burden shifts over to the plaintiff to prove that it will cause delay or prejudice. The Supreme Court went on to say, getting reversed and going down and having to try the case, that's not delay or prejudice. Otherwise, it would be every case would be delay or prejudice. They said, you got to say things like a witness is going to pass away. This thing's going to happen. None of that's here. The other side did not bring forward anything at the trial court level. In their response brief, they just generally recite, well, this is going to be delayed and prejudicial because we need to be paid and we need cash for our business. No citations to legal authority, no citations to the record. The burden shifted over to them. They have not met that. With my last 15 seconds, let me see if I can find you the cite for the meritorious defense.
That's the Jocko v. Rivera you're talking about?
Yes,
Yeah, we
the
can
record
find that.
site is in the clerk's record 14. You will see the attached billing statement. It shows only VA is the party and it's not sworn. That's the site I was using.
All right.
I'm out of time. Thank you, Your Honors.
Thank you,
Thank
counsel,
you.
for your arguments. 14-24-00506 is submitted. We're adjourned.